Thank you for checking out SNU's Contract Bank. I'm Roxanne Smithers, co-founder of Smithers and Ume Wabo, your trusted 360 general counsel. This video provides a brief overview of the Master Ghostwriting Services Agreement. It is specifically tailored for the needs of a writer that is providing ghostwriting services to a client. In most ghostwriting situations, the writer will not be listed as a credited author for the work, but that's something that can also be negotiated between the parties, and you'll see an opportunity for that in the ghostwriting agreement. So the agreement is set up as a master agreement so that it can be used with multiple clients going forward, or if you have one specific client where you're going to be doing multiple projects for them, you can also utilize this agreement and simply do a new services schedule that lays out the scope of work for each individual project. So it's a really great tool for a ghostwriter to have. And so we'll walk a bit through the terms of the agreement. One of the early terms we have in this agreement in Section 2 are the fees and expenses provision. This provision lays out the details that are very important in terms of how you will be paid for your services. Gives you an opportunity to require a deposit from your client, details when you will be paid for any invoices that you submit, timeline for that. And it also provides for a situation in which you may be receiving royalties as part of your compensation, or getting any sort of percentage from revenue that's generated from the ultimate work. This provision also details that if there are any expenses that you are going to incur as part of your services, that the parties can agree that you will be reimbursed for some of those expenses and the process for that. Paragraph 3 deals with changes. If either party wants to make changes to the terms of this master agreement, that has to be done in writing. If the party wants to make one-off changes or exceptions to the terms of this agreement for a specific project, that can be handled in that services schedule. There's a section in there that provides for modifications. Section 4 lays out your responsibilities as the writer, and it provides language with regards to how you will handle client input and the timeline for that client input. Paragraph 5 lays out the process for you to deliver your work product to your client, as well as the timeline for your client to review and accept that work product. Section 6 covers intellectual property rights and ownership of the work product. This provision details that you are providing the work product as work for hire, which means that ownership will rest with the client, and that you will not be listed as an author on that work unless the parties agree to that. You may also be required to sign any additional paperwork to transfer copyright ownership of the work to your client. Section 7 covers any representations or promises that you make with regards to the quality of your work as well as the services that you are providing. Paragraph 8 covers any confidential information that is shared between yourself and your client, that you will maintain that confidential information provided by your client, and your client will maintain any confidential information provided by you. Paragraph 9 details the duration of the agreement, the term, and it also details how the parties can terminate the agreement if they would like to, or terminate a specific services of schedule. This provision details how you will be paid for any services at the time of termination, as well as how any deposits will be handled. Paragraph 10 is the limitation of liability. In sum, this paragraph puts a cap on the amount and or the type of damages that you may be responsible for if for some reason you don't perform properly and it causes damage or loss to your client. It goes hand in hand with paragraph 13, which is a mutual indemnification provision. That in sum means that if either you or your client does not perform properly under the agreement or causes the other party to incur a claim or loss or damage, that you'll be responsible for that loss or damage. Your liability, of course, is subject to that limitation of liability that we discussed earlier. Section 12 and 13 make it clear that both you and your client are free to engage in obtaining services or providing services of similar nature with other parties. You are not exclusively bound to work only with the client in this agreement. Details that you are not an employee of the client and that the client cannot bind you to any contract without your permission. Paragraph 14 details what state law will govern your contract, and it states that the state in which your business is registered or that you live is the state whose law will govern this contract. Paragraph 15 covers what happens in case of a dispute between you and your client. In this agreement, the parties are required to try to negotiate a resolution. They're then required to, at your election, to mediate the matter or to arbitrate the matter. And then whoever is successful has the opportunity to recoup their attorney's fees and cost for that process. You and your client can, of course, agree to different dispute resolution provisions, but we always advise that it's important to have some process in place in case there is a dispute. Paragraph 16 covers how the parties are required to provide notice to each other of issues with regards to the contract. We always recommend that notice is done in writing of some form. Even if things are discussed over the phone, even if things are discussed in text, we do recommend that you at least follow that up with an email to memorialize those conversations. Paragraph 17 covers how the agreement will be interpreted if there is a dispute and it is brought to either an arbitrator or a judge. And then paragraph 18 states that if the arbitrator or the judge finds that any provision of this agreement should not be enforced, that the remainder of the agreement is still enforceable. And then finally, paragraph 19 states that this document is the sole sum of the agreement between you and your client. If you've had prior verbal conversations and verbal commitments that are not addressed in this agreement, then the parties will not be bound by those discussions. So you want to make sure that anything that you've agreed to with your client that's been offered and accepted is detailed in this document. And finally, you will have your services schedule. Services schedule, again, can be utilized multiple times to cover different projects that you may have with your client. It details the services that you're going to provide, the type of work product that can be expected from your client, and a time frame for your services and delivery of that work product. It details payment provisions. It gives you an opportunity to be paid by the hour, paid in a maximum number of revisions, as well as a cost of their revisions that go over that amount. And it also gives you an opportunity to be paid a royalty on any revenues related to the work product. And this depends, of course, if you and your client negotiate that sort of payment. The services schedule also provides you with an opportunity to require a deposit from your client of either a flat rate or a certain number of hours of service, and it details the timeline by which you will be paid while providing your services, as well as the timeline for any royalties that you will receive. And it also has your rate for any work that your client wants you to do that is beyond the scope of this schedule. This services schedule also gives you the opportunity to negotiate with your client to receive a co-author credit if that is something that your client is willing to do and that you want for the work product. It reinforces the confidentiality of the services if you will not have a co-author credit on the work. And finally, there's a section for you to make any one-off modifications to the master agreement. So as you can see, this ghostwriting services agreement is pretty detailed and hits all of the main areas that a ghostwriter would have to consider and options that you can negotiate with your client. If, of course, you have other questions about this agreement or about your business in general, you're more than welcome to schedule a consultation with any of the attorneys at Smithers and Wabo. I want to thank you for coming to the Contract Bank, and I am Roxanne Smithers with Smithers and Wabo, your trusted 360 General Counsel.